on June 17th of 22 in East. Possessed Schedule II controlled substance, which was more than 5 grams, roughly. The indictment says 6.62. It was more than 5, less than 10 grams. That's possession of cocaine, a felony 4. The forfeiture specification for the cocaine, marijuana, and foil. You guys can sit, please. Also a forfeiture specification for U.S. currency in the amount of $100 pursuant to 2981.01B11. On count 2, charge on June 17th to 22 of the that he did knowingly sell or offer to sell cocaine, Schedule II controlled substance, less than 5 grams, trafficking of cocaine, a felony 5, forfeiture specification for the cocaine and the Alcatel cell phone. The evidence showed that a confidential informant was used a audio and video recording device, and that device showed the exchange of the white substance in exchange for the marked bills. The serial numbers were identified on the bills. The photographs or the video, as well as the still photographs, which were States Exhibits 5A through C, show the Toyota, tan color Toyota. They show the exchange between the passenger wearing a black shirt and red shorts, and the exchange of the substance and the money. Once that exchange takes place, a call goes over the radio that the transaction is complete, and then there were officers located on Lakeshore Boulevard that once they saw the car, effectuated a stop. That car ended up at the Dollar General. When the officers arrived at the car, the passenger was occupied by Mr. Nix, who was wearing the same clothing, and the cocaine was seized from the passenger side door, and the bills with the same serial numbers exchanged from the CI at the time of the exchange for the substance were found to be possessed by Mr. Nix. So that is what the evidence indicates in this case, and that traffic stop was within a few minutes after the exchange took place. So I'm going to find that count 2, beyond a reasonable doubt, the defendant is guilty of trafficking of cocaine, a felony of the 5th degree, and order the cocaine and cell phone to be forfeited. On count 1, guilty of possession of cocaine, a felony of the 4th degree, and order that the cocaine, marijuana, and foil are forfeited, and that the at the arrest are associated with drug trafficking activities and are proceeds pursuant to the statute. Mr. Crook, how do you wish to proceed at this point?
Proceed directly to sentencing, Your Honor, should it please the court.
All right. Mr. Nix, you have a right to have a pre-sentence report if you so desire. Are you going to waive that right?
Yeah, I'll waive that.
All right. Crook, go ahead.
Thank you, Your Honor. Your Honor, with regard to sentencing, the court is well aware of the serious recidivism factors and well aware of my client's records. What I would point out that one of the things the court is supposed to consider is this the worst form of the offense? Given the low, barely over the weight to make it a felony 4, and barely in fact, not even a gram on the felony 5. And you, a tenth of a gram would make it a felony 5, but it's nowhere close to a felony 4 trafficking. I don't believe the maximum sentence is in any way justified in this case. On the felony 5, it's any even number from 6, 7, 8, 9, 10, 11, 12. On the felony 4, it's obviously up to 8. Given the court's reasoning as far as the proximity of the two events, I would argue that I believe these should merge, and he should be only sentenced, that the sentences should run consecutive. My client has already been incarcerated for, I believe, 4 months approximately at the moment. I don't know the exact day count. I believe the prosecutor has that. Obviously, he should receive credit for time served. I would ask the court also to take note that my client, while he did initially violate the terms of his bond, did turn himself in voluntarily. I believe that, quite frankly, that this was a close case, Your Honor. I don't know, and the court's obviously found him guilty. That being said, given the nature of the case, given the circumstances, given the low weights as far as reaching the thresholds for a felony 4 and a felony 5, given my client's voluntary actions on turning himself in, I would ask that the court sentence him to the minimum of 6 months to run consecutive on counts, or concurrent, excuse me, on counts 1 and counts 2. Also, at this point, it seems as good time as any, I'd like to make a motion for the appointment of appellate counsel. My client's already instructed me to file a notice of appeal. I'll be doing that after the hearing today, but would ask for an order appointing him with separate appellate counsel so they can review all my work as well.
All right, thank you. Mr. Nix, what do you want to tell me before I impose sentence?
Nothing, sir, because I'm trying to do appeal, so I have nothing to say.
All right. Mr. Hurd?
Thank you, Your Honor. We request the maximum sentence on both counts to be served consecutively. We disagree that this was a closed case. The defendant took no responsibility, as seen by him going to trial in his statements today. Additionally,
It's all, let me stop you there, because, I mean, he's got the right to have a trial, doesn't he?
yes, Your Honor.
And do I have a right to punish him because he goes to trial? I mean, I don't care whether Mr. Nix went to trial or pled guilty. I'm not going to, just so you know, I'm not going to treat him any different because he exercised his right to have a trial. Okay, so go ahead.
Yes, Your Honor, and I wasn't trying to make that claim. He sold crack cocaine, which is a highly addictive drug, and the CI was in his 50s. These accounts shouldn't merge. There's different animus and separate elements, such as him having to sell the cocaine for the trafficking charge rather than just possess. He has an extensive criminal history. The state is working on figuring out jail time credit for the defendant because we were not aware that he was going to request to be sentenced today, but we would request the maximum sentence to be served consecutively.
All right. My look at the docket indicates that he was, at the time of the arrest, how long were you in jail? Right after the arrest? Do you know? Do you remember?
Like 1 day.
Okay. So, and then then he was out of jail because there was a failure to appear, which was a period of about 18 months where you were gone, but you turned yourself in August 1st. So by my count, it's about 117 days that he's served total. So, as I said, in considering all the statutory provisions in 29, 11, 12, and 13, first of all, these don't merge, they're separate animus, but in whether you would come in here and pled to one of these charges, I think at the time when this was in the pretrial stage, there was no offer, it was a plea to the indictment. Okay, so, but the fact that you exercise your right to a trial, makes no difference to me. I don't care whether somebody goes to trial or pleas. Once the determination is made that there's a conviction, then we deal with what the appropriate sentence is. As Mr. Crook indicated, these two actions, these two counts were really at the same time. And I don't know what your intention was with regard to the 6+ grams of cocaine. That's not indicated, and that's not really what's up for discussion. That's a possession of felony of the 4th degree. And so I don't, one of the things Mr. Hurd mentioned was the lack of remorse, which I'm not going to consider because, again, you went to trial and you're going to appeal the case, so I don't expect that you're going to say anything that would indicate whether you were remorseful or not remorseful. Quite frankly, it doesn't really matter to me. Okay? But, so what I'm going to do on count 1, I'm going to sentence you to 13 months in prison. And on count 2, 12 months in prison. Those sentences will be concurrent to one another with credit for 117 days. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months of the time left under post-release control. You have the right to appeal this case to the 11th District Court of Appeals. If you cannot afford a lawyer, one will be appointed for you, and I will, upon Mr. Crook's withdraw from the case and his filing of the notice of appeal, then I'll appoint separate counsel to handle your appeal. You're entitled to have it won't cost you anything, and you'll get a transcript of all the hearings in this case, and if you cannot afford a copy of those transcripts, they'd be given to you at no cost. And Mr. Crook has indicated he will file a timely notice of appeal because you also have that right. Is there anything else, Mr. Hurd? And the items subject to forfeiture are forfeited to the state.
Is the presumption overcome because he's served prior prison sentences, Your Honor?
Yeah, he has served prior prison sentence. Mr. Crook had indicated that. We wouldn't want to upset powers that be. Is there anything else, Mr. Crook?
Not at this time, Your Honor, no.
If you would just file that notice of appeal, then do a withdrawal and ask me to appoint somebody else,